Welcome to a special edition of Off the Clock. Recently, there have been 3 major employment law-related regulations dropped by the federal government. We are quickly recording 3 episodes, 1 on each regulation, to make sure you are up to speed as quickly as possible and have your takeaways about what you and your organizations need to do next. Today, we're going to be talking about the Pregnant Worker Fairness Act and the new regulations, the final regulations that were recently issued.
Welcome to Off the Clock, the webcast of employment attorneys at Miller Johnson, where we discuss what is happening in the HR world and provide practical insight and advice.
For the first time in Off the Clock history, we're dropping 3 episodes all at the exact same time so people can binge watch or listen. So that's kind of weird to think about, but
very exciting.
It is. It's exciting for us because we love this stuff.
We do.
I imagine for a lot of our listeners and watchers, it could be a stressful time with so many things. Breaking news, right? The SHRM and all the Bloomberg and all those notifications.
Yes.
Breaking news.
Right.
Feels a little like COVID, doesn't it?
It does. I mean, I'm not going to lie. On Tuesday, when the regulations from the Department of Labor and the FTC came down, I definitely felt like it was COVID. And I'll just mention, too, we're not going to be talking about them today, but there's also the Title IX regs were released recently as well, and there are also regulations released that had something to do with the fiduciary rule for benefit plans, right? So
we're definitely not talking
this isn't even the end of it. This isn't even the end.
And why aren't we talking about that last one?
Because
we can't.
That's right. But we know somebody who can.
But yes, we have colleagues who can if anyone is interested. All right, let's get down to business.
Yes.
Pregnancy Worker Fairness Act. I always get tongue-tied when I try to say it.
The PWFA.
First of all, let's just frame where we are.
Great.
Okay, because with all the talk this last week about it, I think some people forgot that the law has been in place for a year.
Correct. Yes. There is some confusion on that, right? So the Pregnant Workers Fairness Act became effective last June. Okay, so we have a federal law that's been in place, and the law itself is very broad. It broadly defines what a pregnancy is. It broadly defines an employer's obligations to accommodate somebody who falls under the law as well. What's happened recently is that the EEOC published the final regulations interpreting that law, okay? And a lot of the news stories have talked about the effective date of those regulations.
Right.
That's caused some confusion. I've heard a number of folks say something like, well, we don't have to worry about this then, right, until June, to which I said, well, no, time out. This law is in effect right now. There's an obligation to be complying with the law right now. Some of the ways that the law might or might not be interpreted might not be effective till June, but that really shouldn't, none of our listeners should be thinking to themselves that they have time to delay or time to wait in terms of getting into compliance with these requirements.
And for the folks that listen to all of our episodes, which you should, people may remember we did an episode when the proposed regulations came out. So for any of our listeners that do not study administrative law, because they don't want to fall asleep at their desk, that's the way it works, right? First, a law is passed,
right,
which is a little more general because the law, it just has to be. The law then gives an agency the authority to issue regulations.
To write the rules.
To interpret, put meat on the bones, right? They put out the framework, the law is the framework, here's the meat on the bones. First, there's a proposed regulation. That's what we talked about before and what came out months ago in case people are also confused about that. Right? Why are we talking about it again now? But now what has happened is the final enforceable rule has been
That's exactly
published. So now that we've level set just what we're talking about, Sarah, what are the main points of the final rule that you want to make sure people know right away?
Well, first of all, I'll say it's not much different than the proposed rule. So for those who have been tracking that and listened to the episode, a lot of what we're going to say today probably won't sound new to them.
Good.
The second thing I want to say is this, and this is really important. I want HR professionals in businesses to be thinking of this law like a brand new law. it is like starting from scratch. The Pregnant Workers Fairness Act has requirements that are different from the ADA or the FMLA, and it's got its own rules altogether, right? I've said that several times to clients and others, and they have been surprised. They seem to be thinking, oh, I can just turn this dial over here, or I can use this process or this policy or forms, and I'll be fine. And that's really not the case. This is like learning from ground zero. Now, it's not, I don't think that's insurmountable, but I think it's important to set that expectation. The Pregnant Workers Fairness Act is incredibly broad, the protections and the rights it provides to employees. The headline is very, very broad, okay? Broader than the FMLA requires in a lot of ways, definitely broader than the ADA requires in lots of ways, okay? The first way it's very, very broad is the way it takes that word pregnancy and defines it. Okay?
We all thought we knew what pregnant meant.
Correct.
Turns out we do not.
Correct.
Well, we do now that the regulations are issued.
Yes.
If you thought you knew what it meant to be pregnant under federal law, you were wrong.
Right. And it sort of is like the starting place is pregnancy. That's true. But the regulations, and by the way, the law itself even defines pregnancy to include any limitations that are related to, affected by, or arising out of pregnancy, childbirth, or, and this is the key, related medical conditions. Okay? So we have the term related to in there twice. It's a limitation that's related to something that's related to something. So we are 2 steps away from actual pregnancy.
What did you say about being very broad?
Yes, exactly. That's right. And if we want to sort of shortcut how you might think about it, and I know you've mentioned this to me, kind of anything related to the female reproductive system in any way could be considered, could fall under the definition of pregnancy, which means that if an employee has any limitation at all, physical or mental, then they may have a right to an accommodation in the workplace.
The EOC, when the final regs were released, not in the regs, but in the
Yeah.
interviews, right, said exactly that. Basically anything related to the reproductive system
Yes.
is protected by the statute.
Yes.
So that
That's
could
how
be
we want to think about it.
infertility matters, trying to get pregnant, being pregnant, but also post-pregnancy.
Post-pregnancy,
when the person
that's
is no
exactly
recovery.
Lactation, recovering from pregnancy, menstruation is specifically listed in the regulations, for example. So think about that. And then my brain goes straight to the workplace, right? And think about the limitations then for a huge percentage of individuals in our workplace at all ages
Yeah.
and stages of life, whether or not they're currently pregnant, and the limitations that they might have and what that means.
Yeah, we'll do a whole separate episode on menopause.
Yes.
We don't have enough time.
Yeah, no, we don't.
But that is,
We might need
potentially
wine for that one, but yes, yeah.
wine gives me hot flashes.
That's right.
So I can't do that anymore. Okay.
That's right.
Any other big takeaways about the substance
Yes,
of the
two
regulations?
more in my sort of bullet point elevator spiel about the Pregnant Workers Fairness Act. The second piece is the requirement to provide accommodations is incredibly broad and not at all what the ADA says.
Yeah.
Okay. Put simply, employers are required to essentially do everything they possibly can, bend over backward, so that an employee can continue to work because of a limitation that is related to pregnancy, okay? The last resort possible would be time off work or leave, okay?
But even that's required. Yeah, as I've been saying, find a way.
Oh, of course.
Find a way to say yes. It should be the theme.
Yes.
Right, find a way to say
But don't go
yes.
straight to leave, because
Not
that's it is a direct violation of the law to go straight to leave without trying to find work for that employee. And on that note, finding work, unlike under the ADA, finding work can be a reasonable accommodation under the Pregnant Workers Fairness Act. So providing light duty or restricted work certainly can be a requirement.
Okay. So that's a lot.
Okay, one more. The process is much different.
Okay.
The questions that can be asked, the medical documentation that can be required is much more limited.
With every one of these regulations, we're going to be covering the substance.
Yes.
We're going to be covering litigation.
Yes.
Because COVID taught us every new federal regulation will be challenged.
Yeah.
And where, Sarah?
Oh, in Texas.
Always in Texas,
Always in Texas.
right? So that's always, people ask us whenever there's a new regulation, well, isn't it just going to be challenged anyway? So we'll talk about that, and then what to do, right? What do you actually need to do?
So let's go to the legal challenge next.
Yes.
Is this going to be challenged?
Do people even need to care? Aren't the courts just going to put a stop to it?
I'm actually less, I think that this is less relevant under the Pregnant Workers Fairness Act than under the Department of Labor's rules or the FTC rule.
Okay.
And that is because the breadth of these requirements, many of them are actually in the law itself.
Okay.
Put otherwise, it's not all the regulations' fault, right? So if employers think, oh my gosh, this is onerous, this is burdensome, much of it is actually not because of the regulations. There is one part of the regulations that has caused a flutter, and that is the EEOC made the decision to specifically confirm that abortion falls under the definition of pregnancy, okay?
And that is not in the statute, to be clear.
Correct.
Yeah.
The statute just defines pregnancy broadly, provides the definition I gave, which is any limitation that's related to something that's related to pregnancy, right? Okay, so that could spur some sort of, obviously, that's a hot issue that could spur litigation.
Quick update. Less than an hour after recording this episode, 17 states sued over the abortion accommodations in the Pregnant Worker Fairness Act.
Also, during COVID, I hate to keep referring back to COVID because it kind of gives me the willies, but during COVID, I think we all got accustomed to when one judge made one ruling, usually in Texas, right? It was a big deal and it applied to us everywhere. I think we need to, in that particular matter, transition our thinking. Just because you Google, right, and see a lawsuit that was successful does not mean that the ruling applies to you.
Correct.
So you have to be very careful making assumptions.
My advice to employers would be start getting in. If you're not in compliance yet, you need to start doing that. Speaking of
What a great segue. Speaking of which, what do employers need to do to get into compliance?
Yes.
And I want to, can I just kick it off with the big question?
Yeah.
Let's see if we agree
the most
on this.
popular question
The
we're
most
getting,
popular
which just
question.
scratches the surface, really.
It does, but we only have so much time. This is a great time for a little PSA. We're going to be doing some more in-depth education on these regulations for our clients and non-clients, not on off the clock, but Miller Johnson. We'll be doing some more in-depth, having some more in-depth training opportunities because obviously this is a quick.
Coming soon.
Right, this is just a quick what you need to know immediately type of message. But in the wake of these new regs, the number one question is, should I have a separate policy in my handbook or otherwise that addresses the rights protected by this statute?
Okay.
What is your answer to that?
So here's my answer. Neither the law itself or the regulations require any sort of written policy. Interestingly, it's not like the FMLA, which does.
All right, so you're not out of compliance if
Or
you don't.
any posting, right?
Wonderful.
There's no.
We don't need to
by
order any
not doing
posters.
that, most handbooks that I've seen do have some sort of an accommodation policy in place.
Mm-hmm.
If that is you, I do recommend updating that accommodations policy to include now pregnancy along with accommodations for disabilities, right? Because the omission of it, I think, could be problematic, right?
Could be misleading.
Minimally, I would do that. Some businesses love policies for everything, right? And would prefer a standalone policy for this. That's okay too. But you don't have to.
Okay.
You could just update your accommodations policy.
And the
okay?
reality is, if we do have a separate policy, it's going to look a lot like the ADA policy, right? There's not
For the most part,
because
yes.
it's how we interpret the words, it's the process we use behind the scenes that's so different.
That's just what I was
The
going to
actual
say.
words, because I played around with that for a while and realized it was a little silly to have them right next to each other in the handbook, because I think it would be confusing to
The
employees.
actual words, reasonable accommodation and undue hardship and how to make a request are all the same. It's
Yes.
the interpretation of those things.
Right. Yep.
So,
Okay.
and that's a good segue to the next thing, which is what I'm much more concerned about, okay? And that is process.
Yeah.
Making sure that individuals in the organization know about this change and know how to comply, okay?
Yeah.
So that involves, first of all, educating, of course, our frontline leaders that this important change has occurred. We have lots of leaders who have grown up and understood that, generally speaking, we don't have to go make light duty work for employees who have certain restrictions unless we want to do that, maybe for work-related injury. So long as we have those folks still engaging with employees, they may be violating the law by telling a pregnant employee that we will not be accommodating restrictions.
So to follow up on that, the training for the frontline supervisors, in my opinion, I don't know if you agree, it should be done quickly, because remember, the law's already in place. And it should be, in my opinion, very basic.
Absolutely.
An announcement that there is this new law that protects pregnancy and pregnancy-related conditions.
Yep.
The process for the frontline supervisors is very easy.
Yes. Tell
If
HR.
an employee asks for any sort of change in their
Right.
job, time off, change in job duties, restrictions, whatnot, because of pregnancy or anything related to reproduction, call HR.
That's exactly right.
That's it. It can be as simple as that. We are not suggesting.
It could be 20 minutes. It could be
It's-
15 or 20
Right.
minutes. That's
Just
exactly right.
heads up, this didn't used to be protected, it is now. We have to change the way we do things. We've got you covered, HR has you covered, give us a
got it.
call.
You
Yep,
got it.
okay,
So speaking of which, then the next thing, of course, is educate HR.
yeah.
If you've got a larger HR department, I would probably engage a person to be the point person, the person who's going to be assigned the responsibility of learning this and understanding it. I really think employers almost need some sort of guidebook to understand the requirements of the law, to understand the reasonable accommodation process. They're going to need a different medical form to use in the event that it's allowed. There's not, you can't use the FMLA form or an existing reasonable accommodation form, et cetera.
Okay, so HR has to get up to speed. It will take time, as with all new laws and processes. So in the interim, we do suggest reaching out for help
Absolutely. Yeah.
walking this road with you until you get comfortable with the process, right? I would. I don't. It's just it's too big of a change, right, for people to just know and feel confident moving forward on. So reach out to us, attend training sessions provided by us or others.
Correct.
But get up to speed, and if you feel a little shaky the first time, right, reach out for help, and then the second time you'll feel much better. Just to wrap up with the key takeaways, there's a new final regulation
Yes.
on the Pregnancy Worker Fairness Act. The law is already in place. There were proposed, i.e. draft regulations, some months ago that we talked about then, but now the final ones have been published. They do have an effective date, but that's not really important because the law is already in effect.
You got it.
Right, so you should
You got
consider
it.
them effective today.
Exactly.
Yeah, okay, great, Sarah.
Thanks, Rebecca.
Thank you.